Hello, I'm Floyd Stokes, your instructor for AJ2, Introduction to Law Enforcement at College of the Redwoods. These series of PowerPoint videos are meant to give you an overview of each chapter of the text, but you will still need to thoroughly read each chapter. Today I'm going to discuss Chapter 10, Policing and the Law. This chapter has two learning objectives. 1. Discuss when the Fourth Amendment provisions apply to activities undertaken by law enforcement officers and describe existing rules governing the conduct of searches and seizures. And 2. Discuss existing rules concerning interrogations undertaken by law enforcement officers and the in-court admissibility of obtained confessions, especially as established under the 5th, 6th, and 14th Amendments. All right, let's get started. First off, of all the important legal issues in law enforcement today, the issue of how to properly conduct searches and seizures ranks among the most important. Serving search warrants, arresting suspects, making traffic stops, and stopping suspicious individuals on foot, inventorying impounded vehicles, and a host of other activities requires an intimate knowledge of the Fourth Amendment to the U.S. Constitution. The Fourth Amendment states the following: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or places to be seized. Search is defined as an activity performed to find evidence to be used in prosecution. Seizure is defined as the confiscation of one's person, an arrest, or property by a government agent. Probable cause. Probable cause has been defined by the U.S. Supreme Court as more than bare suspicion. It exists when the facts and circumstances within the officer's knowledge and of which they have reasonable, trustworthy information are sufficient to warrant a prudent man in believing that the suspect has committed or was committing an offense. The court had noted in an earlier case, to quote, "The substance of all the definitions of probable cause is a reasonable ground for belief of guilt," unquote. A more practical definition of probable cause is that it consists of more than 50% certainty. Probable cause lies somewhere below absolute certainty and proof beyond a reasonable doubt, which is the necessary to obtain a criminal conviction in court, but above a hunch or reasonable suspicion, and reasonable suspicion is required to conduct a stop and frisk. See Figure 10.2 on page 152 for an overview of the components of probable cause. Reasonable suspicion versus probable cause. The 1968 decision in Terry v. Ohio was a defining moment in probable cause standards. The Supreme Court ruled that police cannot stop and search citizens on a mere hunch that they might have committed a crime. Instead, specific information creating a reasonable suspicion of a detained person is required. This established what is normally the lowest threshold. Upon a reasonable and specific suspicion, a person can be briefly detained in what has become known as a Terry stop, and searched in proportion to the justifiable suspicion. An arrest, or warrant for arrest, can only legally occur on the somewhat higher standard of probable cause. For a lawful arrest, an officer must have a reasonable and fact-based belief of the party's guilt, since, after all, arrest is the initiation of a criminal law process that will ultimately be determined by legal standards and possibly a trial. Probable cause determination. An individual held in pretrial detention has the right to what is called probable cause determination prior to their arraignment. Though they themselves are not necessarily entitled to be present at the determination or to have legal representation, They can request through their counsel for a judicial officer to review all relevant information allegedly constituting probable cause against them for each offense on which they are being held. In the case of obtaining a warrant, this determination is made prior to the arrest. If probable cause is denied, the detainee is released or no warrant is issued. If it is upheld, the case against them proceeds in an effort to prove their guilt with the sufficient certainty required for conviction. Administrative justification. This is a third level of justification that has arisen by virtue of the fact that the government entities occasionally conduct searches in circumstances other than criminal investigations. The Supreme Court has created a different level of justification for non-criminal or administrative searches, such as sobriety checkpoints, which protect the public by removing drunk drivers from roadways. Most states also have their own exclusionary remedies for illegally obtained evidence under their state constitutions and/or statutes, some of which predate the federal constitutional guarantees against unlawful searches and seizures and compelled self-incrimination. This rule is occasionally referred to as a legal technicality because it allows defendants a defense that does not address whether the crime was actually committed. In this respect, it is similar to the explicit rule in the Fifth Amendment protecting people from double jeopardy. The exclusionary rule judges the admissibility of evidence based on deontological ethics, that is, it is concerned with how evidence is acquired rather than what the evidence proves. For this reason, in strict cases, when an illegal action is used by the police or prosecution to gain any incriminating result, all evidence whose recovery stemmed from the illegal action, this evidence is also known as fruit of the poisonous tree, this evidence can be thrown out from a jury or be grounds for a mistrial if too much information has been irrevocably revealed. The exclusionary rule applies to all persons within the United States, regardless of whether they are citizens, immigrants, either legal or illegal, or visitors. Let's take a look at the issue of arrest. The general rule is that to make an arrest, the police must obtain an arrest warrant. However, if an officer has probable cause to believe that a crime has been committed and there is no time to obtain a warrant, the officer may make an warrantless arrest. An officer may also make a warrantless arrest of persons who commit a crime in the officer's presence. An invalid arrest is not generally a defense to prosecution. However, if an arrest is unsupported by probable cause, evidence obtained pursuant to the invalid arrest can be excluded from trial. After the arrest, the police must follow certain guidelines during their investigations. For example, if the arrestee requests an attorney or expresses a wish to remain silent, the officers must honor the request and refrain from questioning the arrestee. However, the police may attempt to confirm that they have arrested the right person. They may do so by showing a victim a photo array that includes a picture of the suspect, or by arranging a lineup of live persons at the police station with the suspect included in the lineup, or by organizing a show-up, which is a personal showing of the arrestee to the victim shortly after the commission of the crime. Where photo arrays or lineups are used, the police must refrain from highlighting the arrestee. For example, if an arrestee is white, an officer may not show the witness a series of photographs in which all of the other suspects are black. If an identification procedure is too suggestive, any identification by the victim may be excluded from trial. Regarding arrest warrants, a neutral and detached magistrate must authorize the warrant. Magistrates are judges. The officer applying for the warrant must show probable cause through a written declaration or affidavit, and the suspect's name must be specified if known, unless there is a sufficient description that would allow for proper identification. Regarding search warrants, a neutral and detached magistrate must authorize the warrant. The officer preparing the warrant must show probable cause that the items for which the search is being conducted are connected to criminal activity, and probable cause for those items are in the location to be searched. In short, the officer's affidavit must show the items and location with particularity, and as the saying goes, you can't search for an elephant in a drawer. Finally, if the details of the location are not specified, but there is a reasonable basis to identify the location, it does not violate the Fourth Amendment. The bottom line is that warrant preparation requires specialized training and careful attention to detail. Searches and seizures without warrants are far more common than those with warrants. Examples of those are searches incident to arrest, searches based on exigent circumstances, automobile searches, plain view searches, and consent searches. The text describes these in detail, along with important landmark Supreme Court decisions on pages 154, 155, and 156. The box on the right of page 155 describes certain important definitions, such as the arm span rule, the protective sweep, the hot pursuit exception, and evidence, which is evidence that is likely to disappear quickly. The second learning objective in this chapter deals with the rules concerning interrogations, the admissibility of confessions, and the applicability of the Fifth, Sixth, and 14th Amendments. The text looks at three approaches to confession law. Due process or voluntariness is like this. Involuntary statements are not admissible in a criminal trial to prove guilt. Confession is involuntary when the defendant is deprived of his or her, quote, power of resistance, unquote. The courts focus on two issues. One, the police conduct in question, and two, the characteristics of the suspect. The Sixth Amendment guarantees the right to counsel in all formal criminal proceedings and is violated when the government deliberately elicits incriminating responses from a person. There are two key elements. One, deliberate elicitation, or an effort to draw incriminating statements from a suspect who is not represented by counsel, and two, formal criminal proceedings, which includes the formal charge, preliminary hearing, indictment, information, and arraignment. Miranda. This is the 1966 U.S. Supreme Court decision in the case Miranda v. Arizona that led to the rule that statements made by the defendant under interrogation cannot be used in self-incrimination. Prior to interrogation and after arrest, it is required that suspects be read their Miranda rights that makes them aware of their right to silence, their right to an attorney, and the right not to self-incriminate. Unfortunately, many questions are not always readily identifiable as such. In Innis, another case of the U.S. Supreme Court, it noted that in addition to express questioning, the functional equivalent of a question is also possible. The functional equivalent of a question, according to the court, includes any words or actions on the part of the police, other than those normally attendant to arrest and custody, that the police should know are reasonably likely to elicit an incriminating response from the suspect. Figure 10.7 on page 159 lists some factors that are considered when distinguishing between interrogations and general questioning. General questioning would include information gathering questions and conversation not intended to elicit a response. The Miranda decision was not without controversy. Shortly after the Miranda decision, Congress passed the Crime Control Act of 1968, which, among other things, attempted to overrule the Miranda decision. The statute, codified as 18 U.S. Code Section 3501, states that in any federal prosecution a confession shall be admissible in evidence if it is voluntarily given. Under the law, suspects need not be advised of their right to counsel their right not to incriminate themselves, and so on. For several years, Section 3501 remained dormant, but critics of Miranda continued to look for ways to bring it before the court. That opportunity arose in the year 2000. The case involved Charles Dickerson, who had been indicted for bank robbery and related crimes. He moved, through his attorney, to suppress a statement he made to agents from the Federal Bureau of Investigation on the ground that he had not received his Miranda warnings. The district court granted Dickerson's motion to suppress, but also noted that the confession was voluntary, despite the apparent Miranda violation. The Court of Appeals for the Fourth Circuit held in a 2-to-1 decision that Congress, pursuant to its power to establish the rules of evidence and procedure in the federal courts, acted well within its authority in enacting Section 3501. And Section 3501, rather than Miranda, governs the admissibility of confession in federal court. The Sixth Amendment to the United States Constitution is the part of the United States Bill of Rights which sets forth rights related to criminal prosecutions. The Supreme Court has applied the protections of this amendment to the states through the Due Process Clause of the 14th Amendment. The primary focus in this section is on the Fifth Amendment, but for the sake of placing Fifth Amendment confessions law into context, it is important to briefly consider the extent to which confessions are protected by other constitutional provisions. Indeed, the very fact that 3 constitutional amendments place restrictions on how the government can obtain confessions suggests that our country places a high degree of value on the people's right to be free from certain forms of questioning. The due process voluntariness approach. One approach to confessions and admissions is the Fifth Amendment due process voluntariness approach. In general, a suspect's involuntary statement is not admissible in a criminal trial or in any other criminal proceedings to prove guilt. A confession is involuntary when, under the totality of circumstances that preceded the confession, the defendant is deprived of his or her power of resistance. This statement, unfortunately, does not provide any uniform criteria for determining voluntariness. Instead, courts take a case-by-case approach to determine voluntariness. This usually requires focusing on 2 issues. 1, the police conduct in question, and 2, the characteristics of the suspect. Okay, to summarize this chapter, a Fourth Amendment violation occurs when the government actor infringes on a person's reasonable expectation of privacy during a search or seizure. Search and arrest warrants must be issued by a neutral and detached magistrate or judge and require showing of probable cause and particularity. All confessions must be voluntary. The Sixth Amendment applies to confessions and interrogations when officers deliberately elicit incriminating information from an accused person. Miranda requires an attorney to be provided to an accused person who is being interrogated in custody. All right, before I leave, let's take a look at the case Kyllo versus United States again. This is covered on page 163 in this case review. This was a case that occurred in Florence, Oregon, and of course, as you know, it revolves around the use of a handheld thermal imaging device by government agents to determine the heat source in Kyllo's home in Florence, Oregon. The result was this case went completely up to the U.S. Supreme Court, which reversed lower court decisions regarding the use of this technology. And what it has done, it has raised the issue of devices that are not considered in general public use. And this seems to be a phrase that will cover many modern technologies, including those that are not really yet on the horizon. All right, that's it for now. We'll see you in class.